Okay, once again, so now let's talk for a minute about age discrimination. All right. And I always found it a bit funny that the age discrimination law is discriminatory by its own language because it only applies to employees age 40 and up. All right, so it is, to be clear, it is legal to discriminate based on age alone for employees until they have reached their employees and applicants too until they have reached their 40th birthday. So I guess it's something you have to look forward to as you get older. One more thing you can sue on. So what does it do? All right. Well, it makes it illegal to hire or terminate, I should say, an employee because of their age, fail to promote an employee because of their age, and also it makes illegal mandatory retirement for non-managerial employees. So managerial employees are excluded from this. And the reason being, that may not make sense, but the reason being is that at the time of the writing of this, it appeared that there was not much need to protect managerial employees because they are traditionally, particularly upper management, mid and upper management is typically over 40 anyway. So that age group has a lot of representation in the over 40, or I should say that managerial employees typically are over 40 when you get to upper level and mid-level management in your average corporation. It is worth noting that virtually everything we're talking about in this chapter, Title VII, and the ADA, which we'll get to momentarily, applies to employers that have 15 employees. Age discrimination, for some reason, applies. It kicks in with the 20th employee. And if you're saying why, if you're not sure as to why that is, well, the idea is that these provisions can be expensive to comply with and maybe difficult to comply with when you have a smaller company. All right. So age discrimination claims are similar. The progression, I should say, is similar to claims under Title VII. Right? They have similarly that ping pong case. So it starts with the prima facie case, which is really on its face. You have to demonstrate that the discriminated individual was over 40. Right? And just a bit of trivia that you can wow your friends with at your next party. It is common to say, you know, I'm 40 on your 40th birthday, but technically you're 40 the day before your 40th birthday because you're 40 years in a day on your 40th birthday. And believe it or not, that distinction has come up in litigation, right? Because since there are 365 days in a year, you're 40 on the day before your birthday, not your birthday. Anyway, over 40, qualified for the position. So if it's a promotion or your current job, you remain qualified and you were discharged because of your age. All right. And then I didn't continue it out, but it goes to the defense. And the defense, the employer has to show that there was a business reason for the decision that was made, a legal business reason, and then of course the plaintiff would again have the opportunity to show that that's merely pretext and not the actual reason. So the exact same case progression for age discrimination cases. Disability. Discrimination based on disability. All right. And this applies to employers with 15 or more full-time employees. All right. The biggest part here, and if you were to go and read the ADA, which I don't recommend, but you can definitely do. Most of that piece of legislation relates to accommodations provided. Right? It does make actionable discrimination for disability, but it also requires that employers make reasonable accommodations if an employee has a disability. And again, the reasonable accommodations are measured and are pretty standard. Installing ramps, extending levers if you have disabled laborers, making things more accessible. All of those things are reasonable, right? Now, the book in the case in the book, I should say, where the cell phone company needed to rent a bigger parking space for the employee who was wheelchair bound, and his van needed a ramp so he could get out of his van to come to work. Well, that's reasonable, right? It costs the employer more, but that's the cost of doing business, right? Elements of a claim, and this is your prima facie case under the ADA. The employee has a disability, right, which is broadly defined. Qualified for the employment, the job in question, and is excluded because of that, right? And that's your elements of a discrimination claim under ADA, right? And the case progression is similar to that under Title VII. So once the employee and his or her legal team makes that claim, it ping-pongs over to the defense to demonstrate or document or articulate a legal reason for their actions or discriminatory practice, right? And if the accommodation is deemed to be not reasonable or costs too much or too burdensome to the operations of business, that's the opportunity for the employer to make that claim. Okay. And this is a mouthful. Uniform Services Employment and Reemployment Rights Act, or USERRA. And this one's pretty straightforward. It just extends Title VII protection to military service and veteran status. All right. It basically treats military service and veteran status as a protected class under Title VII. So all of the protections we talked about under Title VII are available for your military status.